not a forum, we're going to present Jim Matatal, a tax consultant for over 25 years. Mr. Matatal holds a degree in Business Administration Management from the California University at Los Angeles. He has studied the Internal Revenue Code known as Title 26 of the United States Code and the corresponding Revenue and Taxation Code for approximately 20 years. He meets regularly with the IRS on behalf of clients in need. In the area of audits, his work has usually resulted in either a no-change status or stopping all activity therein with few exceptions. Tonight he'll be talking about related matters and clearing up what he calls many misconceptions about the legality and constitutionality of the Internal Revenue Code and who is under its provisions as stated by the IRC. He will also discuss administrative procedures used to resolve issues with the IRS. Now, without further delay, please join me in welcoming Jim Matatal.
Well, thank you. Nice crowd. Let me start with, there was a comment made before we started taping about where does the money go? The answer is given in the Internal Revenue Code. Where does the money go that are collected for taxes? And the money is supposed to go in a certain place, but it doesn't go there. And where the fact that it doesn't go there was stated by President Reagan when he said that not one dime of income tax goes to support a single federal program. Well, that kind of told me, even he was in a better position to know than I was, that probably not one dime of federal income tax goes to support a single federal program. So what does the code say is supposed to happen with all this money that you send in? Well, the section is 7809, Deposits of Collection. Here's what's supposed to happen. Except as provided by subsections B and C, and in sections 7651, 7652, 7654, and 7810, which if you look those up have nothing to do with what we're talking about here, the gross income of all taxes and revenues received under the provisions of this title being Internal Revenue Code, okay, also called Title 26 of the United States Code. Okay, all the collections received under this title and collections of whatever nature received or collected by authority of any internal revenue law shall be paid daily into the Treasury of the United States under instruction of the Secretary as internal revenue collections by the officer or employee receiving or collecting the same without any abatement or deduction on account of salaries, compensations, fees, costs, charges, expenses, or claims of any description. Okay? Now, that's one sentence. Okay, now, let me ask you, didn't they just say that all the money that's collected by the Internal Revenue has to go to the United States Treasury and they can't offset it for any reason? That's what they said. Okay? Now, how do we know they're not doing that? You buy the endorsement on your check. That's exactly correct. If you put on your check that you send to the IRS, paid to the order of United States Treasury, it will be returned to you. And they will tell you that you have to put on it either IRS or FRB, Federal Reserve Bank. Well, wait a minute. Wasn't the Federal Reserve Bank part of the government? No. Oh, intelligent crowd. You're right. The Federal Reserve Bank is not part of the government, and they'll even tell you that. Okay? So, the code says that everything we get is supposed to be put into the U.S. Treasury, no offsets. They tell us that what they're doing is they're offsetting the deposits for the interest that's due the Federal Reserve. Well, wouldn't that be a violation of the law according to the law? Yes, it would. Who's supposed to complain about that? Congress. They wrote the law. Are they doing anything about it? No. Okay. So we know what the problem is, don't we? Okay. That was the sidebar. Now to the issue. Can I get a drink of water too? Can I get a little cup up here? Thanks. Now, the issue. The Constitution, the Internal Revenue Code, and me, and you. How does it relate? Is the Constitution and the Internal Revenue Code in conflict, or are they in harmony? In conflict, everybody says. I beg to differ. And I'm going to tell you why. Okay? And you'll be surprised. Actually, the Internal Revenue Code and the Constitution are in perfect harmony. Perfect harmony. Why do I say that? Well, after 25 years of studying, I've come to the conclusion that when you read the code and you read the Constitution, that there is no problem. Let me start with where they define things. Okay, let's start with something that everybody is familiar with. Let's start with withholding of wages. That's section 3401C, 3401, but let's go to 3121 of the Internal Revenue Code, which defines something where you're probably familiar with, state, United States, and citizen for the employment tax. Okay? Let's read the definition. State, United States, and citizen for the employment tax. 3121E. State, United States, and citizen for purposes of this chapter, that being employment tax. State. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. Now, which state do you live in? Did they miss you? Oh, well, maybe you live in the United States. 2, United States. The term United States, when used in a geographical sense, includes Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. Now, what part of the United States do you live in? Did they miss you? Oh, well, wait a minute. Is there any more? Well, the other definitions are the same. But let's see. This thing's called the Constitution. This crowd probably has read it. Let's see what it says about the authority of Congress. Now, we all know, I think we all know, that the courts have held that our compensation is not taxable. You know that, right? Okay? And just because I don't want you to just take what I say at face value and not know why I say it, the quote from Connor versus U.S., which is 303 Fed Supplement 1187 at 1191, the Supreme Court said, Congress has taxed income, not compensation. Okay? So, if they've taxed income and not compensation, then why are they doing what they're doing? Well, the reason they're doing what they're doing is because of the Constitution. The Constitution, under Article 1, Section 8, Clause 17, says, starting in Clause 1, Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debt and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises must be uniform throughout the United States. Okay, that's Clause 1. Clause 17 says that Congress has the power to exercise exclusive jurisdiction in all cases whatsoever. Does that mean they can do whatever they want? Yes, it does. Exclusive jurisdictions mean they can do whatever they want. Congress can exercise exclusive jurisdiction in all cases. That's carte blanche. Where? you should be asking. In the United States? No, that isn't what they say. Not here, anyway. This is what they say. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 square miles, I'll give you a hint, as may by secession of particular states and acceptance of Congress becomes the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Now, where do they have exclusive jurisdiction? Washington, D.C., military bases, right? Federal buildings. Okay? They've got it there. Well, that's kind of in agreement with this, what this thing said the state was, isn't it? Because it says the state includes District of Columbia. That means in the District of Columbia they can do whatever they want, can't they? Do they do that? Sure, crime's great over there. They do whatever they want. Okay, so now they also have these other things, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, American Samoa. Where do they get the right to do whatever they want there? Well, if you just go over to Article 4, Section 2, Article 4, Section 3, second clause, it says, Congress shall have power to dispose of and make all needful rules and regulations. Does that give them carte blanche again? Yeah, they make the rules and regulations. Congress can do whatever they want. Where? Okay. They can make all needful rules and regulations respecting the territories or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claim in the United States or any particular state. Okay. The point is, they tell us that in Washington, D.C., and in all the territories and the land purchased by the United States, they can write whatever rules they want, they can do whatever they want, if the legislature will just enact it. What does it say here in the code? That they can take taxes. Washington, D.C., District of Columbia, Commonwealth of Puerto Rico, Virgin Islands, Guam, American Samoa. What are those? Territories? Oh, isn't that what it said here in Article 4? Well, son of a gun. Doesn't that kind of make this thing a little bit constitutional? Sure it does. There's nothing wrong with the code. What's wrong is the people enforcing the code, going beyond their lawful authority. Now, what's that called? It's called operating under color of law. Legal definition, color of law, is acts under color of law of a state include not only acts done by the state officials within the bounds or limits of their lawful authority, but also acts done without and beyond the bounds of their lawful authority. Now, when they try to apply this code beyond what they can lawfully apply it, they are acting under color of law, because it's just like an officer. Does an officer have the authority to arrest somebody? Sure he does. He has that. That's part of his job, right? He can arrest people. If he just goes up to somebody and says, I don't like your face, I'm going to arrest you, that's color of law, because he has the authority to arrest, but there's conditions. The conditions are he's got to have probable cause, okay? Or he's got to have a private citizen complain and put him under a duty to arrest under the private citizen complaint. Okay? So, those are color of law type issues, and that's what's happening with the IRS, the Franchise Tax Board, and all these other people. They're operating under color of law. The law they operate under is good, just like the Constitution is good. I would never get rid of the Constitution. It's been perfect. The problem we've had is what our founding fathers said, which is when, I forget which one, when they came out, I don't know if it was Jefferson or if they asked Franklin, but they said when he came out of the meeting and they were finished, they said, well, what kind of government did you give us? And he said, a republic, as long as you can hold on to it. And one of the others said, the government is made for good people. And as long as good people run it, it will work. Yeah, we got some good ones in there now, don't we? Yeah. So, yeah, exactly. Okay, so now that's one issue. Now, the fact that the government, those are all territorial issues, okay? Where are we territorially? There's another issue. It's called citizenship. How, because if you're in Germany, do you have to pay a tax if you're a U.S. citizen? Yeah, so it goes beyond territory, doesn't it? There's another element. It's called citizenship. So what citizens can they tax according to the Internal Revenue Code? Interestingly enough, you can't find it in the code. You have to go to the regulations. Anybody know what the regulations are for? The regulations are, according to the code itself, which is under 7805. Okay, 7805. Whoops, wrong section. Okay, 7805 says this. Rules and regulations. Authorization, except where such authority is expressly given by this title to any person other than an officer or employee of the Treasury Department, the Secretary shall, which means must. I mean, way back a number of years, people were saying, well, shall means may. Well, that court case that they were talking about did not deal with, most people, they get these things and they read it, or they read what somebody else says about it, and they don't get the picture of what it's talking about. I really can't go into all the court stuff and the meanings of cases and stare decisis and all the other things like that, but shall means must in statutes. Okay, it's not an option; it's a requirement. So when it says the Secretary shall prescribe, that means write, all needful rules and regulations for the enforcement of this title. That means they must write rules and regulations for the enforcement. Enforcement means giving it effect. Otherwise, it's voluntary. Okay? In other words, if you have have you ever heard of enforcing statutes? Or enforcing regulations? We're talking here about enforcing regulations. If you have no enforcing regulations, then according to the U.S. Supreme Court, in the case of California Bankers Association versus Schultz, they said, the Supreme Court Judge Rehnquist said, that no penalties can be applied when no regulations are written, civil or criminal. Okay? So, the question then becomes, are there any regulations for this kind of stuff? But that's what I was showing. You have to go to the regulations, because under section 1 of the code, it imposes a tax. It imposes a tax on married people, it imposes a tax on single people, it imposes a tax on people with children, it imposes a tax on fiduciaries and corporations, and on and on. Okay? Section 1. In fact, this is a lot of fun when I go in with the IRS, because many times I'll ask them, I say, well, okay, we're here for a tax, and I'll say, okay, that's fine. We're here for a legal reason, I presume. And they say, well, we're not here to discuss the law. I said, well, that's fine. I said, again, I guess we're not here for any legal reason then, are we? I said, well, no, you have to be here. Oh, okay. I say, well, if you say there's a tax, where is this tax imposed? Where is the tax created? There's got to be a statute that says there's a tax and the percentages and everything else. I said, here's the tax code. Could you show me where that is? And they look at this. Here's the tax code, 2 volumes, right? They look at this, and I say, here it is. Can you show me where that tax is imposed? And they look at this, and they kind of, well, I don't know. I said, why don't you start in the front? Okay. And they start in the front, and they say, oh, here it is. Yeah, section 1. Didn't have to go very far. I said, very good. Okay. I said, so, now who's it imposed upon? Whoops. No, don't need that. Who's it imposed upon? Okay, section 1.1-1 of the regulation tells you who the tax is imposed upon. And section 1.1 subsection C tells you, well, actually, subsection B tells you citizens or residents of the U.S. are liable to the tax. Well, that's fine. Section C tells you who is a citizen, because citizens or residents are imposed, the tax is imposed upon, right? It says every person born or naturalized in the United States and subject to its jurisdiction is a citizen. Okay? Subject to its jurisdiction. Got this thing again called the Constitution. What does subject to its jurisdiction mean? Does anybody know? The Supreme Court has ruled. I'm just wondering if you're familiar with the case. Won Kim Ark, slaughterhouse cases. Does that ring a bell? No? Well, subject to its jurisdiction means completely and totally subject. Not just a little bit, not just kind of, but completely and totally subject to the jurisdiction, the legal authority of the United States. Okay? Where do we find that? Here in the Constitution, do you think? You know, but you just don't know you know. Starts with a 14. 14th Amendment? Yes. You got it. That's it. 14th Amendment. What's it say? The 14th Amendment, it says, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Well, there it is. The 14th Amendment tells you that these people are the citizens they're talking about that it's subject to. Now, so we know the tax is imposed territorially if you occupy a territory, and it's imposed upon a citizenship if you're in the citizenship that is subject to the complete and total jurisdiction of the United States. Now, before they started the cameras rolling, Jim there was telling us about some cases about double jeopardy, right? About the sovereignty of the state to try somebody a second time. He's tried federally, now he's tried at the state level because it's a different sovereignty. That means it's a different country. After all, what are they doing in Europe? Isn't that the United States of Europe? Aren't those separate countries? Germany, France, Spain, Britain. What are those? Those are countries, are they not? And don't they have heads of states in each one of those countries? Does that mean that each one of those people is like somebody in California, somebody in Oklahoma that's running that state? Because Germany is a state. We all recognize that, right? Germany is a state. How come when we say state and we say California, and we say state and we say Germany, suddenly that term takes on a different meaning? The reality is a state is a state is a state. The California state is the same as the German state. The difference is that we in California, and actually our founding fathers, and the various states agreed to release some of the sovereignty of the state and give it to the federal government. Limited amount of sovereignty. And unfortunately, the federal government has bought the rest. Remember the 55-mile-an-hour speed limit, right? Why did they impose that in California? Because California didn't want to do it. So why did they do it? Does anybody know? They bribed them. They said, if you don't reduce the speed to 55, we're not giving you any money for your roads. So, blackmail. Yeah, okay, blackmail. But that's how they did it. They keep giving money to the state, and so the state says, hey, we'll do it because we don't want to have to pay for it ourselves. We want the federal government to pay for it. So anyway, that's how they do that stuff. So the jurisdiction, the lawful authority, according to the tax code, to tax is based upon the citizenship, and this citizenship is created by the 14th Amendment. And if you read those cases that I mentioned, which is the Slaughterhouse case, the Won Kim Ark case, it goes quite into a lot of detail about citizenship and who is subject to and who is not subject to. In addition, all the attorney generals of the various states, of the 50 states, did a study with the United States Attorney General on just where is the jurisdiction of the United States government. And guess what they concluded? It's in Washington, D.C., all the territories, and on the federal buildings and the military installations. What a surprise. And also the lands that they bought. In other words, the state parks that they actually bought, not just leased or given the right to run. Okay? Same thing the Constitution said. I mean, it took 50 of them, 51, to discover what the Constitution was saying all along, what we know to be true. So now, here we are with the situation. We know that we're not subject to the tax. We know the Constitution says we're not subject to the tax. We know the Internal Revenue Code says we're not subject to the tax. But we know the people we talk to don't know that we're not subject to the tax. That's the people sending you the letters, right? The IRS, the FTB, etc. Do you think Congress knows you're not subject to the tax? Let me read you a little thing before the House Ways and Means of the subcommittee on the House Ways and Means, House of Representatives, 83rd Congress, first session, on administration of internal revenue laws. And this was held February 3rd through March 13th, 1953. Okay? And the people who they were talking to, before then, by the way, 1954, they split the Internal Revenue and the BATF, basically alcohol, tobacco, and firearms. They were one, and now in 54 they became two. This is 53, they're discussing the split. Okay? How is this new thing going to work? Well, we have Internal Revenue and we have BATF. And the person testifying, by the way, is going to be Dwight E. Avis, head of Alcohol, Tobacco, and Tax Division, Bureau, Internal Revenue. It was all one organization. This is what he said on page 13. The question that was posed to him was about appealing a BATF decision. And Mr. Curtis, which was on the subcommittee, said an alcohol tax matter that would go to the appeals section, and then Mr. Avis cuts him off. And he says, there is no such thing. That is where this structure differs. Let me point this out now. Your income tax is 100% voluntary tax, and your liquor tax is 100% enforced tax. Now the situation is as different as day and night. Do you think they know? Of course they know. Okay? It's right there, and there are records. Can't take any questions at the end. Oh, I don't know if they tell you this, but at the end, I can't take any questions here until the end. And at the end, you got to go up to the microphone so it can all go on tape and we can hear what you're asking. All right? They don't trust me to repeat the question. All right. So, now, let's get to some more fun stuff. Oh, one more thing. Since the citizen comes from the 14th Amendment, what do you think a citizen of one of the states would be considered, according to the Treasury Department? Because remember, I'm not giving you my opinion. I'm giving you what they say. Okay? So what do you think they're called? Slaves? Okay. Well, let me show you a case. This is and you may have heard of this case. This was filed by Frank R. Brushaber, complainant, versus the Union Pacific Railroad, which was chartered in Washington, D.C., by the way. This case was filed May 13th, 1914. The complainant, the plaintiff, Brushaber, defines himself, because you always have to tell who you are as the party. Okay? And so he says, Frank R. Brushaber, a citizen of the state of New York, a resident of the boroughs of Brooklyn in the city of New York, brings this bill against the Union Pacific Railroad Corporation, blah, blah, blah. Now, after that case was decided, the Treasury Department have these things called Treasury decisions, where they comment about these decisions that the Supreme Court hands down. This Treasury decision is called Treasury Decision 2313. And it says this: to all collectors of internal revenue, under the decision of the Supreme Court of the United States in the case of Brushaber versus Union Pacific Railroad, decided January 21st, 1916, is hereby held that income accruing to a non-resident alien in the form of interest from bonds and dividends of stocks, blah, blah, blah. Anyway, there's a tax imposed upon it. Wait a minute. The guy who filed the case was Brushaber. The Treasury Department says he's a non-resident alien. Well, you tell me. Is he the one they imposed the tax on, according to the Internal Revenue Code? I don't think so. What's that? That's right. He is not a citizen as defined by the code. Okay. So now what do we do when we get these letters? What do we do when this kind of stuff comes up and you get that letter saying, hey, we need to talk. Right? We're throwing a little party at the IRS. We'd really like you to come. And by the way, bring your papers. Okay. So what do you take? How do you respond to that kind of stuff? Well, the first thing is, who has the authority to invite you over to the IRS according to the codes? That's right. Yeah, the Secretary of the Treasury. But since they define him as the Secretary, in the definitions of the code, it says whenever they use Secretary, it means Secretary of the Treasury or his delegate. So when you go into these meetings, first of all, the idea and what you're trying to do is make a record. Because this person that you're dealing with doesn't know a thing about law. He doesn't know a thing about the Internal Revenue Code. He doesn't know anything about the regulations. So, believe me, you're not going to be able to hold an intelligent conversation with him when it comes to these matters, okay? Because he don't know anything. But he's very willing to not work a deal out. He's very willing to trap himself and say all kinds of criminal and fraudulent things and make himself liable for a lawsuit. Of course, the reason he's willing to do that is because he doesn't know that's what he's doing if you just ask the right questions. Okay? So now, here's the questions. First of all, they send you this little notice inviting you to the party over there, asking you to bring your books and records. Well, let's take a look at that, shall we? I think that's an important issue, books and records. Who's supposed to keep them? Taxpayers are supposed to keep them, but how do you know if you are a taxpayer who's supposed to keep them? Okay, I'll answer the question. Section 6001. By the way, has anybody ever seen these letters they send you? Yeah? Yeah. Okay. They also send you this little notice called Notice 609. Okay, Notice 609 is a summary of the Privacy Act. Also, usually on page 4 of your Internal Revenue, your booklet, the 1040 booklet, they put the Privacy Act. But I think they've moved it now. Too many people are reading it. But they tell you in the third paragraph of that statement that their authority to ask for the information is Internal Revenue Code 6001, 6011, 6012A, and their regulations. So let's check that out, shall we? What does 6001 say? 6001 has to deal with keeping of records. Well, who's supposed to keep those records? I mean, inquiring minds want to know. So, this is what it says. Every person liable for any tax imposed by this title. Well, who's that? What tax are they talking about? Well, we won't worry about that just yet. Okay, any person liable for any tax imposed by this title or the collection thereof shall keep such record, render such statements, make such returns, and comply with such rules and regulations as the Secretary may from time to time prescribe. Period. But that's not the end of the sentence. How do you know if you're one of those people who have to keep these records? Well, the Secretary tells you in the next sentence. Whenever in the judgment of the Secretary it is necessary, he may require any person by notice served upon such person or by regulations to make such returns, to render such statements, or keep such records as the Secretary deems sufficient to show whether or not such person is liable for a tax under this title. So how do you know if you're a person who's required to keep records? The Secretary will tell you. Has anybody ever got that notice? No? Has anybody ever filed a tax return? I think it's called voluntary. Okay? Now, now understand that serve is not the same as send. Serve is legal service. That means, at the minimum, it requires registered or certified mail. And really, it should be personal service. But I'm assuming nobody got that. However, it does say that the regulations could prescribe a requirement. So let's check it out. Regulations under 6001. Okay, regulations, by the way, this is really interesting, and the government is really good about this. That's why the IRS knows nothing about this that I'm going to tell you. Okay. See this book? This is the government printed regulation. Okay? This is the Code of Federal Regulations, and this is the last book. There's 50 titles in the regulations. If you ever go into the government bookstore down here in Los Angeles, you go through the door, you turn to the left, and you turn to the left, and you look at that wall. And that wall is covered with books like these, the regulations. 50 titles. And guess what most of that wall is composed of? Title 26, income tax regulations. Now, this book here is the last one. It's called CFR Index and Finding Aids. What it does is it tells you what the it tells you various things. The regulations have like we're looking for 6001, right? Well, there in the regulations you find that they're composed and broken into parts. There's part 1, part 2, part 3, part 4, part 5, and on it goes. The parts, what do they mean? Well, they tell you in the first title what the parts mean. I know this is a little bit strenuous, but bear with me. That says the parts are numbered in Arabic throughout each title, and then it tells you that each section, let me see if I got it right here. It says that each agency is responsible for the accuracy and the integrity of the citation of authority in the documents, but the part number itself is, hopefully I've got it highlighted, which I don't. Okay. Oh, here we are. Parts. Okay, this is under the regulations 21.9. And it says parts, subparts, and undesignated center heads. The normal division of a chapter are parts, consisting of a unified body of regulations applying to a specific function of an issuing agency or devoted to a specific subject matter under the control of that agency. So what does the IRS control? Taxes. So what are the parts composed of? The types of taxes. Right? In other words, if you want to know what tax that you're required to pay or what tax they're talking about, they have to give you a part number. Because over here, you'll find that in the in the index and finding aids, it lists every single part number under Title 26 and what it means. For instance, on page 964, under, I know you can't see this, but under 964 it has Title 26 Internal Revenue Code. Now, usually if you ask the IRS what kind of tax you're talking about, they'll tell you it's income tax. Okay, don't got a problem with that. Income tax, Part 1, income tax. Okay? So in order to find out all the regulations for income tax, you have to look under Part 1 of the regulations. If they're trying to collect on income tax and there's no regulation for that particular function, like liens and levies, they can't do it for that particular tax. So, I said all that to preface that when we look at the regulation, it's going to be preceded by a number. In this case, the regulation is 1, well, we know that's income tax, 0.6001. Okay, so we know that this regulation, therefore, is dealing with income tax because it's a 1.6001. Now, we also see that it has a 20.6001, it has a 25.6001, 31.6001 on it goes. Okay, 20, by the way, is estate tax, 25 is gift tax, 31 is employment tax. Each one has its own record-keeping requirement. Okay, everybody pretty confused so far? Okay, good. Okay, then I must be from the government. Okay. Basically, when you go to the regulation, you look up the code section. Okay, so the code section we're looking up is 6001. You'll see that right here, 6001. There's a number before it. That number is going to tell you what tax this code section in the regulation is talking about. Because there are lots and lots of taxes in the Internal Revenue Code, obviously one regulation is not sufficient to cover it all. After all, do you think the record-keeping requirement for income taxes would be the same as employment taxes, which would be the same as the black lung tax, which would be the same as the gas guzzling tax, which would be the same as the coal mining tax, etc.? Obviously not. Each one of those would need its own sets of record-keeping requirements. Therefore, the regulations are separate for each one. Now, we're talking income tax. So, income tax, it says this, because we read that they were supposed to send us, right, actually serve upon us a statement saying we're required to keep these records. But they said the regulations could tell us to do it. Okay, here's what the regulations say under income tax. It says, generally, this is under 1.6001-1A, which is records. In general, except as provided in paragraph B of this section, any person subject to a tax in the subtitle A of the code, and it gives, or any person required to file a return of information with respect to income shall keep such permanent books of accounts or records, including inventories sufficient to establish the amount of gross income, deductions, credits, stuff like that. So it says everybody except the people in paragraph B have to keep records. Paragraph B says this is the exception to keeping the records. B, farmers and wage earners. Oh, wait a minute. Isn't that pretty much everybody here? You're the exception to keeping records. Well, then, what are you required to keep? Well, here's what you're required to keep. Individuals deriving gross income from the business of farming and individuals whose gross income includes salaries, wages, or similar compensation for personal services rendered are required with respect to such income to keep such records as will enable the district director to determine the correct amount of income subject to the tax. Well, that means some of your money's not subject to the tax. In fact, the question is, which money is subject to the tax? That's the record you're supposed to keep. Well, that's not it. Well, it's not finished there, okay? It is not necessary, however, that with respect to such income, the individuals keep the books of accounts or records required by paragraph A of this section. So you don't have to keep all those records. It tells you. How do you know if you're required to even keep those records that it's talking about? Section B, notice by district director requiring record statements or the keeping of records. Oh, there it is. Okay, well, here's how we're going to know if we're required to keep records. The district director is going to tell us. The district director may require any person by notice served upon him. You're going to receive a service of a notice. And that notice, notice served upon him to make such returns, render such statements, or keep such specific records as will enable the district director to determine whether or not such person is liable for the tax under subtitle A of the code. Well, the reason you'll know is because the district director is going to do some legal service on you. It's going to tell you specifically which records you need to keep to have available in case he wants to make an inquiry as to whether your money is subject to the tax. Now, has anybody received that notice? Well, then you must have volunteered. I guess. Is that what they call that, voluntary compliance? I guess so. Okay, so now you know. Okay, now that you know that, what good does it do you? Okay. Here's what good it does you. they tell you that, number one, the secretary is allowed to do this, the secretary is allowed to do that. The secretary is allowed to do just about anything in this code. The secretary is the one who's allowed to do it. Or the district director if they prescribe by regulations. But it usually doesn't get much lower than that. When you go into a meeting, or if they invite you to their little party, and you go in, the first thing that you want to ask them, and you tell them, hey, I'm here to cooperate, I want to do everything I'm required to do, I don't really know what that is. But one of the things that I do know is that that the requirement is that either the secretary or his delegate has the authority to do something. I need either the secretary there, or I need the delegation authority from the secretary down to you, showing you have the authority to do whatever it is you want to do. Now, how do we know we can ask for that? That is stated in Federal Crop Insurance Corporation versus Merrill. The U.S. Supreme Court said that it is our duty to make sure that whatever government agent or agency we're dealing with has the authority to do whatever it is they say they want to do. So, who has the duty to make sure this agent is operating within his lawful authority? We do. It is our job. And if he is not willing to do it, then it is our job to document everything that goes on so you can sue him. Okay? Because then he's operating in the color of law, violation of Title 42, and on it goes. So, when we go in, we first preface and we say, well, this is what I do anyway. Okay, going in, I'm going to bring counsel, going to bring a certified court stenographer, obviously we're going to record the meeting, and I'm going to bring a witness. I need you to have present, according to California Bank Association versus Schultz, I need you to provide, along with the other court site which I just gave you, which is Federal Crop Insurance Corporation versus Merrill, I need you to provide your delegation of authority order. I need for you to provide your proof of service that I was supposed to keep records, showing that I was served, and the notice was given to me showing that I was supposed to keep some records. And after you provide all that information, we can get on with whatever it is you want to talk about. Okay? We usually run into a problem. Okay. I send a letter before I go to the meeting stating everything I'm asking for because I want them prepared, right? I'm acting in good faith. I'm not trying to hit them from the blind side. I'm telling them exactly everything that I'm going to be asking for, who I'm showing up with, what we're going to do, and that we are going to cooperate. Okay? But the first thing they have to do is very simple. Just show us they have the authority to ask for the records. You know, the funny thing is, I've never seen those delegation of authority orders. They've never had them. Well, how can I turn over private, confidential records, if I had any, to this person who doesn't have the authority to receive it? So we put on the record, we ask if they got the letter. Of course, we always send it certified, so we know they did. And we ask them if they read it, and they said yes, but it means nothing, and all this other kinds of stuff, which means nothing to me because they got it. Don't care what they think about it. And then we say, okay, please bring forward your delegation of authority orders. Well, we don't have to do that, and then it just goes back and forth. Then I said, okay, you did get the letter. You knew we were going to be asking for it. This court case said, which we cited in the letter, that you had to bring this forward. You had to prove up your authority. Do you have that authority? Oh, yes, we do. Then where's your delegation of authority order? Oh, well, we don't have to bring it. We have to bring it forward. I said, well, you know, I don't know who you are. I don't know what you are. You may be the janitor in this building. All I know is that you told me, and this is what I always ask this to, I said, are you the secretary of the Treasury? No. Oh, well, then you must be his delegate. Oh, yeah. Bring forth the delegation order showing you're his delegate. If they can't do that, then they're not his delegate. And I say, well, then you bring somebody here, because we told you you had notice that we were going to ask for this. So you bring forth somebody with authority, by virtue of his delegation authority orders, to receive any information we have. And we'll be happy to turn over everything we have once we have somebody who has the authority to receive it. nobody has the authority to receive it in those buildings because they never bring anybody forward. And so what we're doing is we're setting a record, because setting the record is one of the most important things you can do administratively. Because what they do is they're making a record. They're writing things in the little book. When they mail out stuff, they put things down there. They take your letters, and they take the letters you receive, and if they're really bad, they put them in your file. And if they're really good, that means that's really bad for them, good for you, they put it in a different file. And when your file is presented to the judge, those letters don't seem to make it. I wonder why. But anyway, that's okay because you kept the original. You never send the original to the IRS. You always keep the original because it requires original documents to be put into the court. So remember that when you send these things out. Now we're setting the record. We've set the record that we're willing, we want to cooperate, we're there to cooperate. We just need somebody who has the authority to receive it, and hey, we're ready to move forward. They never have anybody. But now let's say they go the next step. Let's say they say, well, you no good tax protester, refusing to just bow down and let us walk on you. We'll show you. We'll go to, they'll issue a summons maybe. That's the same thing with the summons. Do they have the authority to issue the summons? No. Oh, but the summons is really fun. But, should I go to that? Okay, yeah, I'll go to that. Okay. Summons. First of all, summons. What section authorizes the summons? 7402? 7402 or 7604? Okay, 7602. Okay, 7602's enforcement of summons. That's 7604. The issuing summons is 7602. Authority to summons. There it is, 7602A. Authority to summons for purposes of ascertaining the correctness of any return, making a return where none has been filed, determining the liability of any person for any internal revenue or the liability at law or in equity of any transfer of or fiduciary of any person with respect to any internal revenue tax or collecting of any such liability. The secretary is authorized. Oh, well. Is he the secretary? Well, we need those delegation of authority orders again. But that's just the beginning. Assuming that they actually bring some up, which I've yet to see, you need to know where you go next. And where you go next is the CFR finding and indexing aids. Where's the enforcing authority for 7602? Well, it happens to have in this book on page 799, but we're going to have to go over 7602. Okay, 803. 803. It says here 26 USC 1986 Internal Revenue Code, and it's got the code sections. And down here we find 7601 to 7606. Well, 7602 is within that. And it tells us the enforcing regulations for that. We look over here and it says 27 parts 170 and 296. Oh, wait a minute. That's the IRS is 26. Well, 27 is definitely not 26. So, what is 27? Well, let's take a look. Go to the back of the book. We look at 27 and look at that. Alcohol, tobacco products, and firearms. And it said 170 and 296, right? Well, let's see. 170, that part number is under miscellaneous regulations related to liquor. Anybody here do that? No? Okay, 296. Miscellaneous regulations relating to tobacco products and cigarette papers and tubes. Anybody here do that? Well, there you go. All your records that relate to liquor and tobacco products, you must bring with a summons. That's why I always have them bring a box with all their tobacco products and cigarette information in it. Okay? Okay? And we're ready, okay, to produce anything that may be necessary, assuming they give me that delegation of authority order. Because after all, we don't know what they're after. And the summons are so vaguely worded, but that's what we do. And we're there to cooperate. We want to cooperate. We're good citizens. Okay? All we want is for the government, i.e. its workers, to obey the law. Okay? They seem to have a problem with that. What's that? Yeah, okay, well, employers, that's another issue. But anyway, this is assuming we're at the IRS level. Now, let's say that you have a notice of levy or a notice of lien. Okay, and you say, this doesn't seem right to me. I'd like to have a meeting with you, i.e. IRS. I'd like to have an administrative hearing. Okay, administrative hearing. This is authorized under Title V of the government codes. Title V, United States Codes, Section 556D says, except as otherwise provided by statute, the proponent of a rule or order has the burden of proof. Well, who's asking you to do something? IRS. Guess who has the burden of proof? IRS. A sanction, is a tax a sanction? Yeah, it is. A sanction may not be imposed or rule or order issued except on consideration of the whole record or those parts thereof cited, means stated, by a party and supported by and in accordance with the reliable, probative, and substantial evidence. Did they ever provide any records, information, cites? No. So if you're the only one with that, I guess you're the only one with evidence in the record. Huh. Okay, a party is entitled to present his case or defense by oral or documentary evidence, to submit rebuttal evidence, and to conduct such cross-examination as may be required for a full and true disclosure of the facts. That is what you're allowed at an administrative hearing. Now, everybody ever got that when they went to the IRS? Maybe you didn't ask for an administrative hearing. That's okay. If you do, they won't give it to you. But they're required to, which means if they don't, they've denied you your administrative due process remedies, and you can either get a declaratory action, a lawsuit, or a few other things going because you've been denied your rights under the law. Okay? That means everything they've done is set aside. So if you owe $100 million and they didn't give you your due process rights, you owe nothing. And that's what the court tells them. Okay? But you have to, and that's another issue, how to go to court and how to fight this kind of stuff, and I won't get to that right now. Because we'd be here till, next week? Yeah. Okay. So let's get into that lien and levy thing. Okay? Lien and levy, right? You ask for your hearing. So you ask for your administrative hearing. You come there and you find out they got this one little guy with a tape recorder who's probably the janitor, and he's going to record this meeting. And you're there with your stenographer and your witness and your counsel. And you then ask the question. Of course, they're not going to have the lawful authority to do anything, but that's not the question. The question is this: what kind of tax are you trying to collect? And they'll tell you. An income tax. Or they'll say a 1040 tax. You say, well, show me where a 1040 is a tax in this code. Of course, they can't. Say, well, in the front of the code, it says that there are a couple of different types of tax here. Income tax, estate tax, gift tax, employment tax, excise tax. Which one of those are you trying to collect? No, income tax. Good. The index here says that under Internal Revenue Code, an income tax is a Part 1 tax. The Internal Revenue Code says that if it's a levy, that authority is issued under 6331 of the code. A lien, by the way, is 6321 of the code. Now, since it's an income tax you're trying to collect, and 67805A says that you must have enforcing regulations, and since the Supreme Court says you can't impose a penalty, which includes a tax, without enforcing regulations, here are the regulations for the income tax, which I give to the agent. I say, please find me 6331, authorizing a levy for income tax, or 6321, authorizing a lien for income tax. And I many times tell them, by the way, I've got it marked here for you so it'll be easy to find. So we turn there, and we find that in the Code of Federal Regulations printed by the government, Part 1 for income tax, under here we've got 6302. Well, that comes before 6321 and 6331, doesn't it? 6302. The next regulation we find is 6361. You know, that sure sounds like it comes after 6321 and 6331. Guess what? No enforcing regulations for a lien or levy for income tax. Now, this is all on the record, you understand. And I look to the agent and I ask him this question. If you do something that the law doesn't authorize, doesn't that make you liable? He says, well, we always do this. This is our policy. Okay. I say, well, how often has the court said that policy is no excuse, as well as ignorance of the law is no excuse? All the time. Policy don't make a difference. And I said, now you know. I said, before you may not have known that you could not have issued this, but now you do know that you cannot issue this. And since you know you cannot issue this, will you now release this thing, since you know it is unlawful? And suddenly they find that they don't have the authority to do it, which, by the way, I've already asked them if they had the authority to do it when we started. So they're lying. But now we have on the record that, number one, they know they don't have the authority and they're not going to correct their error. Guess what that is? It's actionable. Actionable in court. You can now go to court because they've admitted, and that's where I was saying before, they don't know when they're convicting themselves, but they've put it right on the record. Okay, yeah, gee, it's not in there. No, I'm not going to take it off. Well, that's like that's like the officer coming to you and saying, I'm going to arrest you because I don't like the looks on your face. And you say, well, here, show me in the law where that is. Well, gee, I can't find it. That means you can't do it. Well, I'm going to do it anyway. Okay? Now, it's no longer by ignorance, which means only when you do something by ignorance, usually there's no a penalty applied. There's no, what's the term? There's no punitive damage. But now that he's doing it intentionally, willfully, and maliciously, you can go after punitive damages, which is above the costs of what is being, basically above the cost of whatever it's cost you, whatever it's taken. Because without that, you can only recover your cost. But when it's malicious, intentional, you can recover punitive. And of course, that's what you want. You want them to pay through the nose. But, okay. And, a lot of these people are ignorant, and I give them that, and I grant them that. And I give them the opportunity to correct their mistake. If they won't correct their mistake, it's no longer ignorance. Okay? It's intentional willfulness, and they're criminals. Those people need to be taken to court. The ones who make a mistake, and who are willing to correct it, I have no beef with. There's a lot, considering not percentage-wise, but a lot as far as number of people, agents who are actually good people. But there's also a larger number who are not, who are just there. And most of those larger numbers, by the way, are in collections. Funny how that works out. But there's a lot of good agents who really don't know. And once you inform them, they make changes. In fact, even some agents have quit the IRS because of that. But anyway, the point is that you can address this issue. You can go after them, and you can present this information, and stop them cold using their own codes, their own laws, their own rules, their own regulations. You know, here's something that most people aren't aware of. It's another Internal Revenue Code. Got them all over the place. What does the agents have authority to do, and which agents can do it? The code tells us. That's good to know, right? Now, under 7608, it has authority of Internal Revenue Enforcement officers. Okay? Now remember, people garnish your bank account, steal your cars, stuff like this. Which agent can do that according to the code? Nobody knows. Okay. Sure you do. You just haven't read it. It's right here. Okay, I'll read it to you. Right here. There you go. You can read it. No? All right. Here's what it says. Authority of Internal Revenue Enforcement Officers. A. Enforcement of Subtitle E. Subtitle E, by the way, is where you find liens and levies. Enforcement of Subtitle E and other laws pertaining to liquor, tobacco, and firearms. Oh, how about that? Did you know that Subtitle E for liens and levies related to alcohol, tobacco, and firearms? Sure, we looked it up, didn't we? They also tell you right here, enforcement of Subtitle E and other laws pertaining to. Okay, that's just the title. So you can't build a case on the title. I got a really interesting story about that, which I'll get to in a little bit. Remind me, in case I forget. Any investigator, agent, or other Internal Revenue officer by whatever term designated. Okay, so it doesn't matter what you call them. Whom the Secretary charges with the duty of enforcing any of the criminal, seizure, or forfeiture provisions of Subtitle E or any other law of the United States pertaining to the commodities subject to tax under such subtitle for the enforcement of which the Secretary is responsible may. Okay, here's what they may do. Carry firearms, execute and serve search warrants and arrest warrants, and serve subpoenas and summons issued under authority of the United States. Okay? So those people who are collecting liquor, tobacco, and firearms as an investigator, an agent, or another Internal Revenue officer. Okay? So they can carry firearms, they can serve search warrants, they can serve subpoenas and summons. But that's only related to alcohol, tobacco, and firearms. Those people can do that. Okay, B, enforcement of laws relating to internal revenue other than Subtitle E. Well, that means everything that's not alcohol, tobacco, and firearms. Any criminal investigator of the Intelligence Division or of the Internal Security Division of the Internal Revenue Service, whom the Secretary charges with the duty of enforcing any of the criminal provisions of the revenue laws, basically it says the same thing, they can execute search warrants and arrest warrants. So, if it relates to ATF, then they can carry firearms, they can do search warrants, and they can serve subpoenas. Any agent in the ATF can do that by whatever term he's designated. If it's other than Subtitle E, and therefore other than alcohol, tobacco, and firearms, he has to be a criminal investigator of the Intelligence Division or the Internal Security Division of the Internal Revenue Service. Now, have you ever asked that guy who's doing that stuff, or asked the bank who receives those notices, what was the title of the agent? And what was his function? Who served this on you? Because, after all, the law says only these people can do that. And if that bank or whatever released the information on a warrant or a notice of levy that didn't have the authority to be issued in the first place, then they're liable. So these are the two types of people who can issue these things. So if it's with income tax, basically, it has to be a criminal investigator who goes around and does that stuff. And I don't think too many people, those people are up doing that. Now, so there's another thing you can talk about. which I never have to talk about because it never comes up. We never get that far. We never get past delegation of authority. Okay? Everything else I've given you is just stuff that hopefully they'll give me a delegation of authority and we can talk about the other stuff. But until they give me that, we can't go anywhere. And they're operating in bad faith. And, the whole idea here is that we want to operate in good faith. We want to have what the court reads if we have to go to court, what the jury would read if we're in that situation, to show that we are bending over backwards to do what the law requires. And our record shows that we've been very compliant and very willing. It's the IRS agents who have been unwilling to do what the law requires. Now, if you're on a jury and you get this record where the person is saying, hey, I'm willing to produce everything I have, whatever I have, as long as you can show me that you have the authority to receive it. And if you don't have that, bring in somebody who has the authority to receive it, and we can continue. And by the way, I told you I was going to be asking for this, so why didn't you have it in the first place? You think the jury is going to look at you and say, oh, you rotten, no good tax protester? No, of course not. You're going to say, well, he's only asking for what the law says. Why didn't they give it to him? That's what I'd say if I was on a jury. Is that what you'd say if you were on a jury? And the record, we got the record, and it shows that you are always saying, hey, I want to comply, I want to cooperate, I want to do this. And he's saying, no, I'm not going to give that to you. I don't care what the code says. I don't have to discuss the law. Who's the bad guy here? They are. There's no tax protester at that meeting. There's only citizens who want both sides to obey the law. And once you have that, you'll win, they'll lose. That's the whole idea. There's a lot more I could get into, but let's see, what time is it? Oh, it's only been an hour and a half. Oh, I was going to tell you about the... Okay, yeah. Okay, this is really funny. Going to court? Okay, let me give you this story. This is going to court. As a matter of fact, we had a situation where we came in, there were summons for records. Well, I wasn't, but, my client was. He was summons for records, come in and produce the records. We sent our letter, told them what we were going to show up with. We're going to have 2 witnesses. We're going to have a court reporter. We're going to have counsel. He was going to be there. And we're ready to go. So we come in, and we're waiting in this little foyer. And the IRS come out into the foyer. I mean, a horde of them. And so we said, wow, I've never had a horde of IRS agents come out all at once to meet us. Usually one person comes out, they escort us all to the room, and then the horde's there, but not out in the hallway. So the horde comes out, and I say, oh, I can see what's going to come down here. And so I tell the court stenographer to say, okay, set up and start recording. So we're out in the hallway, and they're putting up their stuff and getting ready. And the IRS agent's already talking, right? And I got my recorder on, because I always bring a recorder, and I turn that on immediately. And so he's saying, well, you can't have all these people. And they say, well, did you get the letter, telling you that we were going to have these people, and we gave you 10 days to object. Did you send a letter objecting? Oh, we don't have to do that. Well, bad faith. Okay, it says, well, this is actually you do. It says, we advised you we were going to have those people. We told you if you didn't want them or didn't want this party here, that you should tell us that. And you didn't do it, therefore you consented, and here we are. And said, well, you can't have all these people. You can only have the stenographer as a witness and yourself. Oh, you can't have counsel. No, you can't have him. No, that was me. So anyway, I said, okay. He says, we're here. He had his box all taped closed, records marked all over. Records. I said, you shouldn't have put records. You should just keep the box, because we don't know if we have any records yet, because we don't know what they're asking for. And so we don't know if there's any records in there, because there may not be. There might be, but there might not be. So we didn't know. So we said, okay, well, we got the box here. We're ready to go. And they said, well, we're not going to let you make a show of this. And so, well, we're not making a show. We just want to have our meeting. We just want to proceed. And they said, well, we're not going to do that. We're going to cancel this meeting right now. I said, so then you're canceling the summons? We're not going to have a summons? Well, we'll collect the tax another way. He said, oh. Says, so, okay. And so anyway, then they get the CID in there. That's a criminal investigation division, to escort us out, right? So they're there. I mean, they were there from the beginning. That was part of the horde, the CID was there. And so they come in, or they're there, and they said, okay, well, we need to escort these people out. And they say, well, pack up your stuff and go. And he says, okay, well, we're still making a record. I say, now, anybody want to give me their names? This is someone in the CID, because you can act as a witness. And they said, no. They didn't say no. They just went. And I said, okay, they're shaking their heads, no. None of them wanted to testify against their fellow agents or say their names or anything else. So it didn't matter. We had plenty. So we packed up and we left. Well, then the agent filed an order to show cause called an OSC. An order to show cause is you can only do that if you refuse to turn over your records. Now, we have a stenographic record that says we were willing. We just needed to have the meeting, which they weren't willing to give us. Okay? So guess what he did? He perjured himself on his declaration, because he said he refused to turn over the record. And our record, the stenographic record, says no. We have over 12 times where we said, hey, we want to cooperate. We want to do what's required, et cetera, et cetera. And we have the IRS saying, well, we're going to close this down. You know, you have to get out of here and all this kind of stuff. Well, so they do the order to show cause. We do an answer. Our answer is, we were willing to cooperate. He wasn't. He perjured himself. We want you to sanction the agent. Well, then the U.S. attorney took a while to answer, because he's probably trying to figure out what to answer. I have never seen such a stupid answer in my life. This guy, I don't know who he is. I feel sorry for him, kind of. But he came back with things, he sounded like he was under a paranoid delusion in answering this thing. He was talking about, well, his concept of the world he's trying to impose upon us. What does that got to do with a court document, you know? Imposing your concept of the world? This is a court state. You know, you're supposed to state facts, not go off on some crazy mental tangent. And then, remember I said about the title, that the title of something, because I said, hey, you know, this summons wasn't even signed according to 6065, which requires signature on the penalty of perjury on any document issued by under any rule or regulation of the Internal Revenue Code. Said, now, that wasn't on there. And so what he did is he cited the caption, which said penalty of perjury required on returns. Okay? And when you read the law, it says on returns, lists, or any other document. So the title, and that's why they don't let the title be ruling over the law, because the title is just a summary. And he pointed to the title and said, this only applies to returns. See, this is what the heading says. I mean, a first-year law student knows you don't cite the heading and say, see, this is controlling. But that's what he did. So, then we answered, and we brought up the point that this guy was apparently delusional, because he thought that we were trying to impose the world upon him personally. And then he was making statements about he was a tax protester and all this other kinds of stuff, and he was doing this and that. Well, the attorney wasn't there. How would he know what happened? So he's making first-hand witness testimony in his answer, and he wasn't even there. Well, that's fraud. That's also a violation of his oath of office, by the way. Then he also cited the title. So we, of course, had to tell the judge, that, we understood that the title wasn't controlling, and we understood that first-year law students understood that the title wasn't controlling, and perhaps the government was reaching before the first year to pull these people into government service. Because he obviously didn't understand. Well, usually in those cases, the judge comes back with an answer within a couple of weeks. And it's been over 2 months, and we haven't heard an answer of how he's going to rule. But we know that the judge is either going to throw the thing out because this attorney just blew it. Not that he could have saved it anyway, but he blew it. And even if he orders him to produce, it's an appealable error. Because we have the record showing we were willing. And the only way you can do an OSC in order to show cause is if we refused, which we didn't do. So we are moving against the agent under the perjury clause that he perjured himself, and we're going to be filing a lawsuit against him. Yeah, it's a lot of fun. This guy's a real pain in the kazoo, and so it's fun to make him feel the pain, you know. But anyway, that's what I wanted to tell you about. That was a really funny thing. I've never seen anything like it. And if you guys get involved in this stuff, you can enjoy this kind of thing too, you know. Because, you know, I don't know if you know this, but all the U.S. attorneys were fired when Clinton came into office. They were all replaced with his cronies, so there won't be any prosecution of Clinton, at least not from the U.S. office. But anyway, it shows the caliber of the people that he's found fit to fill that office. So, and I also know a secretary of the government, of the federal, the secretary of one of the judges, and she said that the people, the attorneys used to be men of character and quality, wherein if they didn't have a right action, if they were wrong, they would say, hey, the government's wrong here, let's drop this. Said the people in there now, they don't care. It's just to win. We're just going to win. We don't care, right, wrong, indifferent, we're going to win. Which makes them liable to lawsuit, and among other things. But anyway, just know who you're dealing with, and you can have a lot of fun at it. Because when you got God on your side, you know, you can't lose. Well, we'll have to answer the questions at the end because nobody else can hear you. Now, let's see, courts. I actually have a tape, which Dennis has back. Must be over there. Oh, and back there. Anyway, I have a bunch of tapes. He has a list of the tapes on how to do audits, how to deal with the FTB, how to, you know, do a lot of different things. And you can go back there and get those. One of those things is how to deal with a court issue. And basically, it's an overview. It doesn't give you all the details. There's books that give you that. But it gives you the overview details on how you take an issue and take it to court, what things you're going to go through and what steps you're going to take, you know, how you're going to do something, what they're going to do back and forth, and on it goes. But again, it's an overview. It's like an outline because there's not enough time in 2 hours to give you all the details, what the judge is going to say, what you're going to say, and all this kind of stuff. But there's books that do that. There's a book by Nolo Press called called Represent Yourself in Court. Oh, another one. Okay, thanks. And that book goes into a lot of detail. It doesn't tell you how to write a complaint, but it does tell you how to take your complaint through court. Now, there are other books. If you want to write a complaint, there's a real easy way to do it. You go to your law library, you ask the librarian there, where are AMJUR? That stands for American Jurisprudence. And she'll take you back, and there's two sets of books. There's AMJUR, and then there's AMJUR Pleading and Practice Forms. So you look up your subject, whatever it is that you want. And then once you find your subject, and it talks about the things you want to do, what kind of lawsuit or whatever you want to do, you then look up the AMJUR Pleading and Practice Forms under that same section in the other book series. And it has the complete case already done. All you have to do is fill in the blanks and probably change a little bit of the facts, of course, to fit your facts. You don't want to say that the police did this when you're talking about an IRS agent, but it has your whole case is already done for you. All you have to do is put on the captions, put on the signature line, the verification at the end. Anybody know what I'm talking about? Okay, some people do. Okay, when you put the complaint together, you got to have a caption, the court name. That's in the local rules. It tells you how many lines down it is, what the name of the court is, and you put over here who's the party. Actually, over here who's the party, unless you're looking at me, and over here you put what type of complaint it is, and then you put who the parties are, why they're parties, where they reside, why the court has jurisdiction, and after all that's done, you actually start talking about what you want to talk about, which is the complaint, what you're complaining about, and why you think they're liable, and what you're asking for in damages. At the end of that, you sign it, and because we're not attorneys, we have to put a verification wherein we say all the stuff is correct under penalty of perjury. and it's just a one-page thing, and it's called verification. It's just it's the same statement saying, yeah, everything on here is correct. I know it's first-hand knowledge and all this stuff. And then you have a proof of service behind that. So that's the thing about courts, and a very quick overview on how these complaints are kind of put together. By the way, I'll give you a very quick summary of a court. You file a complaint, you serve the parties. Okay, make sure you serve all the parties, because if you don't serve the right parties, your complaint can be thrown out, and or that person who you want to include won't be a party to the action. After you do that, they file an answer. After they file an answer, you then can either file a response to their answer, or you can not file anything and wait for the court to actually for the next steps. The next steps after that is pretrial motions. Pretrial motions, or a lot of different things, but I won't get into those either. We'll be here all night. But anyway, you've got pretrial motions. Then you have usually a little conference that you get together, and it's called a settlement conference. You're supposed to talk about settling the case, maybe discharging it or agreeing, which attorneys never use it for that, especially with people who are not attorneys. They try to intimidate you and get you to drop your issues. But anyway, after that pretrial conference, you then go into the actual trial, and at the trial you present your information. They'll present their defense to it. Okay? Then you call up witnesses and you put things into evidence. You call up all your witnesses, and then they cross-examine each one as you call them up. And then they call up all of their witnesses, and you cross-examine each one as they're called up. And after that's all over, you do a closing argument, and you should always reserve some time, ask the judge to reserve some time so you can have the last say. Then he does his closing argument, and then if you reserve that time, you can then comment on his closing argument with your little bit of reserved time there. So the plaintiff has the advantage of speaking first and speaking last, which is always good. That's why the plaintiff usually wins, if you know what you're doing. Okay, but it's all procedure. That's what they teach the attorneys in school, is procedures. Anyway, that's the overall of how that case goes. And then if you don't like the decision, you can do an appeal. An appeal is not introducing more information. An appeal is saying the judge made an error, or there was an error in this decision, and it's all procedural. No new information is introduced. You have to take the existing records, the existing evidence, and show why it's a mistake on the basis of what the judge decided. And so if you can do that, you can win your appeal. If you can't do that, you'll lose your appeal. Then you can appeal that appeal to the Supreme Court. But anyway, that's how it works. That's the whole process. Okay, well, if you have some questions and stuff, I guess you're supposed to go back to the mic back there, and you can ask me a question so they can hear. Well, thank you.
I have a few questions. What is employment tax?
What is employment tax?
Yeah.
Well, employment tax is a particular type of tax in the Internal Revenue Code. And it's basically one that's only paid by the employer. You have, of course, federal tax. You have FUI, which is federal insurance, federal unemployment insurance. You have FICA, which is Social Security. You have Medicare, and which is obviously the Medicare insurance type tax. So that's just one of the number of taxes. But when you read, if you're wondering about the definition of state in the United States that's referenced there, when you look at the other definitions in the code, you'll find that they're the same. That the references to state in the United States is always the same, except for in about one place where they're talking about trading information with the states. And there they say that state includes the 50 states. Actually, they say it means the 50 states. So anyway, the employment tax is just one of the many taxes they impose on people who have quote-unquote employees.
In other words, it's not volunteer. It must be paid, or it's not?
The question is, what's an employee and who are employers? Well, the Internal Revenue Code gives you specific definitions under 3401C, excuse me, who an employee is. 3401C defines an employee. For purpose of this chapter, that's withholding of wages, the term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of one or more of the foregoing. The term employee also includes an officer of a corporation. So if you listen to those definitions, an employee is somebody who works for the federal government, the state government, lives in Washington, D.C., or is an officer of a corporation. Officer being president, vice president, secretary. Okay. Now, if you, an employer, by the way, which is 3401D, it says for purpose of this chapter, the employer means the person for whom an individual performed any service of whatever nature as the employee of such person. So you can't be an employer unless you hire an employee. Okay. Now, wages, 3401A says for purpose of this chapter, the term wages means all remuneration for services performed by an employee for his employer. So wages is something that an employer pays employees. An employer is somebody who hires employees. An employee is somebody who works for the federal, state government, lives in Washington, D.C. Okay?
Okay. You quoted some court trial, and I would like to know, you tried them or they who filed that case?
Who files a case in court?
Yeah.
Well, the case in court is filed by the plaintiff. The plaintiff is the person making the accusation.
No. You were giving us an example. What happened in the court? Who was the plaintiff?
Who was it? You mean his name?
No. You were talking about some case, and I missed. Who was the plaintiff in that case?
Well, that's what I'm saying. I don't understand your question. Who was the plaintiff? You mean what is the name of the plaintiff? Or was it...
Did you ever try these IRS agents for acting under color of law?
I haven't personally had to go after any of them under color of law yet. But there is this one guy who we may do something with because he is a real irritant. But there are, if you read the federal cases, Bivens versus 6 unnamed federal, I think it's, let's see, Bivens versus 6 unnamed. I don't remember if it's federal officers or agents of the Bureau of Alcohol, Tobacco, and Firearms. But it's a very common act. It's called Bivens. If you just say Bivens, anybody who knows anything about cases knows what you're talking about. Because it was done by a gentleman named Bivens, went after 6 ATF agents who did not reveal the names, refused to give their names, and the agency tried to hide them. And he sued them as a Title 42, and it's called a Bivens Actions, and it tells you how to do it, basically. So that would be a way to find out.
Thank you very much.
No, you're welcome.
Can you tell me why the all IRS agents are paid for on their payroll checks by the Department of Agriculture?
Well, no, I can't tell you that. Why they're paid from the Agriculture Department, because I actually don't know why they're paid from anybody. But the fact is that your Social Security number, and this may be a reason, though I really can't say that's what it is, but if the place where you were born, not your Social Security number, but the place where you were born, in their county records, they've got your birth certificate. If that place burns down and that birth certificate is no longer available, guess where you can find your birth certificate? You can find it in the Federal Office of Commerce. So your birth certificate is in the Department of Commerce. I must tell you something. Now, the other thing is that they used to put your name in upper lowercase on your birth certificates, and now I think they only put it in uppercase. But you don't have to get a birth certificate. You don't need one. If you have 2 people who contract, say you were born, like mother and father, some witnesses say, yeah, this was born, this was his name, etc., that's just as good.
Like in the front of your Bible?
Pardon? Yeah, like in the front of your Bible. Or even separate contracts for all the atheists, which I hope there aren't any.
Thank you.
You're welcome.
Yeah. Good evening, Jim. You mentioned the Bruchaber case, which is a foundational case for understanding this income tax. That was a unanimous decision by the court, and the first of many cases that declared that the income tax was constitutional, unanimously, because it was an indirect tax. Pointed out plainly, and that these people were subject to the tax. And the part that's so hard for me to understand is for the next several decades, there seemed to be no question. People in this room, as wage-earning employees, were never subject. There was no problem.
It wasn't until 1941 with the attack of Pearl Harbor.
Correct.
That they started having the W-4. And that was only for federal workers, though the newspapers failed to tell everybody that it was only for federal workers. And so everybody else just volunteered into filing that W-4. It was basically a war tax.
So the question I have is, we really come down to two great classes, taxpayers and non-taxpayers under the code. And,
that's right.
And most all the people in this room are non-taxpayers.
That's right. As a matter of fact, the Supreme Court and the economy heating and plumbing case stated that there are two classes of people. There are taxpayers and non-taxpayers. What that case specifically dealt with was that an individual or a company, the IRS went and took their money, and they weren't liable for that tax.
Just like all of these people every week.
Right. But
their money is taken.
But the interesting thing was that they did say that as a non-taxpayer, and that's one thing I forgot to add, which I wanted to add at the end, that as a non-taxpayer, you have no remedy in the code. The code only deals with taxpayers.
That's right, and that's why you have no business in their offices. That's why you have no business with them, because you're a non-taxpayer. But you're going in and operating as a taxpayer. You can't blame them for looking at you as a taxpayer. You're acting like a taxpayer. You're walking like one. You're talking like one. You're carrying records like one. But you're not one. You're a non-taxpayer. Okay. And if people would get that through their heads, I think we could get this whole thing solved a lot simpler.
Well, the problem here is even though you're a non-taxpayer, the government is going to treat you like a taxpayer. And unless you establish a record, they are going to roll over you. And
That's
your only
correct.
remedy is going to be in court, and then you're going to have to fight the issue that you didn't show up, you didn't do this, you didn't do that. And so if you can establish the record right at the beginning, you're not admitting to be a taxpayer when you come in there.
You want to make plain that you're not.
And that's part of the process, is that if they do refer to you, and in my cases, when they call the person a taxpayer,
Right.
I say, well, that hasn't been established yet. The taxpayer is specifically defined as somebody owes a tax.
Absolutely.
And we haven't established he owes a tax, so please call him by his proper name. Because after all, if we let the term taxpayer stand, then it's presumed that you agree you are.
That's right.
Because you either protest or object to the terms stated, or you agree. And that's the way it is in court cases. If you don't object to what they're saying, or if they file a complaint and you don't answer all the issues, then whatever you didn't answer, you agree to. That's
Thanks,
the same
Jim.
thing with the record.
Thank you.
Sure.
What are the steps involved and procedures when going in for employment, when you sit down doing the paperwork?
Going in where?
If you get hired, once you go in, fill out the paperwork.
Oh, you're talking about as in somebody wants to hire you?
Yeah.
And you don't want to fill out that W-4?
Well, what does he need to do and not do during that whole process?
Well, see, the W-4 in the 3402 F2 states that it's for an employee to give his employer. Obviously, if you're not an employee, you're not supposed to give it to him. When you sign that thing under penalty of perjury, you're testifying to the fact under penalty of perjury, which, by the way, is 5-year penalty if you lie, that you are an employee. In other words, you're required to give them this form. Well, obviously, the IRS then rely on that and say, okay, well, if you're an employee, Well, then we'll need to hold taxes. Need to hold taxes on this employee. If you're not an employee, the problem that you have, of course, these workplaces have no idea that this is the case. And they say, well, the IRS tells us you must sign this as an employee. Well, as an employee, yeah, they're correct. But if you're not an employee, obviously not. But the problem is that these places don't know. The best that you can do is, which won't do any good talking to these large corporations because the people they hire don't know a thing about the law. They just do what they're told. Best thing you can do is attach an affidavit to it stating that you are not claiming to be an employee as defined in the Internal Revenue Code by filling this out. That you are claiming to be an employee as defined in the dictionary. And you can cite like Webster's or whatever, because the two are defined differently. And that you are not an employee as defined in the Internal Revenue Code under 3401C. Okay? And by doing that, at least it sets the basis that if they want to say that you signed this W-4, you can say, no, I never claimed to be a government employee. I never claimed to be one under 3401C. My affidavit states as such that I'm not claiming that. I'm filling this out because I have to get a job. And you can put that in your affidavit. They won't give me, they've told me they refuse to hire me without me filling this form out, so I'm filling it out under protest and duress, but I'm filling it out because they require it for me to work here. Well, anything done under protest and anything done under duress is a non-signature, so it's just like you never signed it. And if you got an affidavit to that effect and they don't mind, it's just like you never filled it out. At the end of the year, now you're going to have to take another procedure to claim the taxes back that they've taken out. And that's a whole new subject.
Can you use exemption on there so that you're getting all the money on the federal level?
Use the what again?
Use the words exempt where it says on that box?
No, exempt.
What?
You see, exempt is something, here's the rules for exempt. Exempt is somebody who had no tax liability last year, won't have one this year, okay? But that deals again with somebody who's an employee. And you could claim exempt, but what they're going to do is, if they want to get nasty about it, they're going to hit you with a $500 frivolous filing fee or penalty. And, if you don't want to go through that, then don't put exempt, put the maximum number of deductions. In fact, you're better off to put a whole bunch of deductions rather than putting exempt down on the form. Because if you could exempt, it automatically goes to the IRS.
Then what line do you put the... they have different lines for different amounts of one person, two people, on different lines.
Are you going to file a tax return at the end of the year?
No, but you're saying you put the maximum amount of deductions.
Well, you're putting the maximum number of deductions. You see those numbers, each one of those deductions represent $2,650 currently. So each one you put down there, you're knocking $2,650 off of your taxable income. So what you do is you take what you're going to earn for the year, divide it by 2,650, and you put that number down. Because that'll wipe out the tax.
Okay. All right, thank you.
You're welcome.
Hi, Jim. A question regarding regulations and how they give force to the statute. You mentioned California Bankers Association versus Schultz.
Yes.
Another friend of mine says that the statute must call for a regulation within the statute for there to have a need for a regulation.
And that's under 7805A. I read that.
Okay. He also said some statutes are self-executing and they don't need a regulation unless they call for it.
Well, they would have to spell out that they're self-executing. It's not a case of, gee, this one feels like it's self-executing,
Right.
They'd have to have some verbiage that would show that it's self-executing. Also, the Supreme Court said that without statutes, no penalty can be applied. So something that's even self-executing without the regulations is going to still not have the ability to punish you without those regulations, because the code is just broad authorizing language. The U.S. attorney said that in California Bankers Association versus Schultz. So if that's broad authorizing language, how in the world can you possibly determine what you need to do or not need to do? That's what the regulations are about.
So there's no court case that says a statute does not need a regulation?
No.
There's nothing that's overturned or
No,
conflicted
actually, the court cases, when you read them, talk about that you got to have regulations, or that you look at the two together and determine the meaning, or that if the regulations go beyond what the statute says, then the regulations are limited by the statute itself. And so, but there's never any place that says that the statutes don't need regulations. They always say that, they always use them either one limiting the other or something like that, or they talk about one and they don't even talk about the other.
Okay. So if a statute doesn't have a regulation, then there's no enforcement.
That's right. It's voluntary at that point. And one of the interesting things under 7201, 7202, 7203, which is tax evasion.
Willful failure to file.
Yeah, willful failure to file is number 3, but
Yeah.
number 2 is failure to pay the tax.
Right.
Under those, there's no regulations.
Right. Okay.
And they don't argue the point, which is, where's the regulations? The second point you argue on that, it says any person required. You look under 7343, it defines the term person as a corporation or a partnership. So, how can I be a person as defined in those statutes? Because that's a corporation or partnership.
Right. Right. Thanks.
What's the difference between audit, summon, and hearing, if any?
Between an audit and a hearing?
Or summon?
Well, a summons is a document they send out to tell you they want you to show up and bring stuff. Okay? And what the IRS issue is called an administrative summons, which means they can't enforce it themselves. They have to go to court to get any kind of force behind it. An audit is where they invite you to come in and voluntarily disclose all your private information. I mean, that's the reality of what it is. What they're saying is, hey, you've got some information here. We think that it's questionable, or we want to question it, even though you signed under penalty of perjury and it's a sworn statement. We're going to ignore that, and we're not going to sign anything under penalty of perjury to call into question your statement. We want you to voluntarily renege on your sworn statement and just give us the information. That's essentially what they're asking for on an audit. But an audit is basically just looking at your books and records to determine if what you put down there is accurate according to their rules. An administrative hearing is a request to have to look at whatever it is that you want to look at, which in particular would be if they say that any person liable has to do something, you want them to show you where you're that person who's liable. And if you are liable, you want them to show what tax it is that you're liable to and where the code says that you're liable for that tax. Because after all, if you're not the person liable and they don't have a tax imposed upon you, what are you doing there?
The frivolous penalty notice, if one answers that, what happens next? If you don't hear from the IRS, you just let it drop? Take all your money out of the bank, or what?
If they do what?
If they send you a frivolous penalty notice.
Oh, frivolous filing penalty? Well, the frivolous filing... What?
The $500.
The $500
Yeah.
frivolous fee, right? Well, that's under 6702. 6703 tells you that any penalty imposed under 6702, the burden of proof is on the IRS. And obviously
I know what it says, but they don't seem to know what it says.
No, they know.
Yeah.
And the other thing is there aren't any enforcing regulations under 6702.
Well, how do you protect yourself? You go to the bank and talk to the bank manager and see.
You mean the IRS then has sent a notice of levy to the bank? Well, long before that, when they send you a little thing saying you have this frivolous filing penalty, you should ask for a hearing for them to prove up that they have the regulations to prove.
I have done that. They won't grant me the hearing.
Okay. Did you do that in writing?
Not yet.
Well, if it's not done in writing, you didn't do it.
Okay.
Because anything done over the phone without written documentation didn't happen, don't exist.
I've gotten one voided, but
Okay, well,
pending the hearing.
You've got to, whenever you deal with these agencies, you've got to plan to go to court. In other words, everything you do should be on the basis that you're going to go to court, and you got to show it to the judge or the jury. You can't show them a conversation unless it's in letter form.
Okay. Based upon things you said tonight, there's a couple of legislation bills pending where they might come out with a flat tax or a revenue tax, like a sales tax. Mm-hmm. Would that make it a legal tax if they did either one of those? Is one better than the other, or should we try to?
Well, the flat tax and all the other taxes, the value-added tax, the sales tax, the problem that I see with all that stuff is, number one, they have no jurisdiction to issue that kind of tax.
Either one?
Either one.
Okay, because I was thinking if it was a sales tax, that might be a legal tax.
A sales tax could be one, but the problem is they can't impose it in the states because they have no jurisdiction in the states.
Okay.
So they can't force the states to put on a sales tax. The second problem is that the other one, the flat tax, doesn't meet the problem with the flat tax is where does it end? Because even though it starts at a certain point and it gets rid of the IRS, which is a good thing,
right?
At least as far as income taxes, they'd still be around for ATF and that kind of stuff. But they're also going to be around to collect that flat tax, you know. But basically, the flat tax, it may start at one point, and it's just like what they've done now, where they've taken away the personal interest write-offs, and they've taken off, you know, you used to get all your medical deductions. Now you lose 7.5%. In other words, you deserve to be sick, 7.5% of whatever you make. And casualty losses, they limit it to 10%. In other words, you deserve to have people steal 10% of what you own before you can ever write it off. Okay? And they talk about limiting charitable deductions. What they're trying to do is take away your write-offs.
Right.
Now, after they take away all your write-offs, which they do with a flat tax, now all they do is raise the percentage, and what can you do to compensate? You're completely at their control.
Is there any protection from the Social Security tax?
Pardon?
The Social Security tax. Is there any protection from that?
Protection against Social Security?
The tax that they have on there.
Yeah, work for yourself.
Right. Well, okay.
Or if you work for somebody, generally, again, if you work for a large company and stuff like that, they don't know that you should be paid out of accounts payable, not out of payroll, because payroll is only for government workers, etc. So if they got you in payroll, they're going to take it out.
Okay.
And there's no way to exempt yourself.
Thank you.
Jim, I heard your lecture in Hermosa Beach. There's a meeting every first Tuesday of the month at 7:30 at Scotty's Restaurant. It's right on the beach near the beginning of the Hermosa Pier on 1100 The Strand in Hermosa Beach. And if anyone is interested, these little catalogs are available right here. They have all the information on it. It's every first Tuesday of the month, Hermosa Beach near the pier. The Strand Restaurant. Telephone number is also on this little catalog. It's for the ones who don't get one. 310 area code 318-7152. I personally attended some of these meetings, and if you think Jim is good with IRS matters, you should hear him on traffic issues. Great fun.
Thank you.
Okay, we want to thank Jim for coming tonight. Let's give him a big hand for everything.
Thank you. Okay. Thank you.
How you doing?
I'm doing good. How about you?